Under Hindu law, the concept of desertion is not considered as simply withdrawing from a physical location, but rather as withdrawing from a state of things, meaning a deliberate abandonment of the marital obligations and cohabitation, signifying a clear intention to forego the responsibilities of marriage. Essentially, it's about leaving the marital relationship, not just a particular place. Key points to remember. State of things, interpretation. This means that even if a spouse is physically present in the matrimonial home, they can still be considered to have deserted their partner if they are actively refusing to fulfill their marital duties and responsibilities. Relevant legal provision. This concept is primarily found in Section 13(1) IB of the Hindu Marriage Act, 1955, which defines desertion as a ground for divorce. Under Hindu law, desertion as a ground for divorce refers to the act of one spouse permanently abandoning the other spouse without any reasonable cause and without their consent, essentially meaning they leave the matrimonial home with the intention of not returning and ending the marriage, allowing the deserted spouse to seek a divorce if the desertion continues for a continuous period of at least 2 years. This requires both a physical separation, Factum deserendi, and the mental intention to permanently abandon the marriage, Animus deserendi, to be established. Key points about desertion as a ground for divorce under Hindu law. 1. Legal basis. Desertion is recognized as a ground for divorce under Section 13(1) IB of the Hindu Marriage Act, 1955. 2. Elements of desertion. Factum deserendi, the physical act of leaving the matrimonial home. Animus deserendi, the mental intention to permanently abandon the marriage. 1. Duration of desertion. To be considered a valid ground for divorce, the desertion must continue for a continuous period of at least 2 years before filing the petition. 2. Constructive desertion. Even if one spouse does not physically leave the matrimonial home, their conduct can sometimes be considered constructive desertion if they make it impossible for the other spouse to continue living with them. 3. Reasonable cause. The court will consider if the deserting spouse had any reasonable cause for leaving the marriage, such as cruelty or adultery, which could negate the claim of desertion. Important considerations. 1. Proof of desertion. The burden of proving desertion lies with the petitioner, who must demonstrate the fact of separation and the intention to permanently abandon the marriage. 2. Reconciliation attempts. If the deserting spouse attempts to reconcile and resume cohabitation, it can be considered a termination of desertion. And 3. Case law. Courts often refer to past case laws to interpret and apply the concept of desertion in specific situations. Here are some past case laws on desertion as a ground for divorce under Hindu law. 1. Lachman Utamchand Kirpalani vs. Meena alias Motor, Air 1964 South Carolina 40. This case held that desertion does not occur if a spouse abandons the other in a state of temporary passion, such as anger or disgust, without intending to permanently end cohabitation. 2. Prabhavati, AIR 1957 South Carolina 176. This case held that desertion requires 2 essential conditions for the deserting spouse. The fact of separation. The intention to permanently end cohabitation, Animus deserendi. 1. Savitri Pandey vs. Prem Chandra. This case held that desertion is the permanent forsaking and abandonment of one spouse by the other without consent and without reasonable cause.